Yes, Mr. Malik.
Lords, before I address you on my additional grounds 2 and 3, may I just very quickly deal with a point that arises from the questions that my Lords raised earlier this morning.
Just give us a second. So sorry, I'm just ordering another notebook, Mr. Malik. Do forgive me.
Yes. So my Lords will recall that I took you to page 227 of the core bundle in SCL's case, which is the revocation decision. And of course, I showed my Lords paragraph 80 and 81 of the revocation decision. My Lords put to me entirely properly that, well, the Secretary of State says that she has considered the impact of the revocation decision. There's no question about bad faith, so why we should not simply proceed on the basis that the Secretary of State has done what she has done.
Could you just give me the page number you're on again?
Page 227 of the bundle.
The last page.
Yes.
Thank you so much.
So it's paragraph 80 and 81. I have made submissions on the point generally, but may I ask my Lords to look at the very first sentence of paragraph 80 again. So at its highest, assuming that I'm wrong about everything that I said about it, the Secretary of State says that we always take into considerations impact revocation may have on the sponsor. But this case is not simply about the impact on the sponsor. That is one of the 4 points that I make. What about the impact on skilled migrants and their families? What about the impact on the care sector? And what about the impact on those in care? Now, the Secretary of State is not saying, that she has considered those matters, impact on skilled workers, care sector, and those in care. The Secretary of State's case is that those matters are irrelevant. And if you look at the judge's reasoning, the judge below said that, well, there isn't really any engagement by the Secretary of State as to these 3 matters, the impact on skilled workers, care sector, and those in care.
Well, there are 2 points here. One is page 214.
Yes.
Paragraph 3, as my Lord observed this morning.
Yes.
They do say, we have considered your representation.
Yes.
Now, that sentence is not confined to the impact on a sponsor.
Yeah.
And at the moment, at least, it seems to me that unless there's any evidence to contradict that assertion of fact, we have to proceed on the factual foundation that they did consider all of the representation. Now,
yes.
That's the first point. There's a distinct point which you're entitled to make and which may be a good point or it may be a bad point, which is that isn't enough. That if, as you put it, if they haven't engaged with the other points, and the judge may be right about that, and that's the key issue, as I understand it, which arises in the Secretary of State's appeal against paragraph 55.
Yes.
But I don't think that turns on the first point, which is simply a factual question of did they consider your representation?
Submissions. Yes. So those submissions were before the Secretary of State. The Secretary of State, of course, considered those submissions.
Yes.
And in fairness to the judge below, he did not grant the judicial review claim, saying that, well, those submissions weren't considered at all. I mean, he granted a judicial review claim, saying that, there isn't proper engagement, lawful engagement with these matters. And that is the part of the decision that I respectfully invite the court to uphold.
You rightly say that in paragraph 80, they only refer to consideration of the revocation on a sponsor.
Yes.
You say from that, what can one conclude from that? You're not saying that it follows from that they must have overlooked the other impact, are you? How do you put it?
What was considered was the impact on the sponsor alone. Miller and friends for the Secretary of State have not said that the impact on skilled migrants and their families was actually considered. That isn't the submission that the Secretary of State makes. It isn't submitted by Miller and Friends that the impact on care sector and the impact on those in care was actually considered. That isn't the submissions that the Secretary of State makes. The Secretary of State says that those matters are not relevant.
I think we understand that.
Yes, I'm good. So just moving on to my additional grounds 2 and 3. So what I propose to do is to address the court on the 2 additional grounds together. There is some overlap, and of course I only have 40 minutes or so to address the court on the 2 grounds. Now there is no dispute between the parties, my lords, as to the proper approach to the interpretation of policy documents. The question of interpretation is a question for the court. A policy document should be read objectively in accordance with the language that is used, read in the proper context. All this is fairly well settled. So with that in mind, may I just respectfully take you to the relevant parts of the policy guidance. The guidance documents are in the supplementary bundle. And may I take my lords to page 235 first.
I think we were told that the documents are different. Or have I misremembered that? Are the documents the same in the 2 cases, or are they different?
They're not the same,
That's
other
right.
than that it's a different version, but all of the material provisions are on the same wording.
Same wording. Do the paragraph numbers change at any point, inconveniently?
I don't believe any of the
Okay,
paragraph
fine.
numbers.
Fine.
I think one does, but otherwise it's...
But of course, there is no issue of genuine vacancy in the other appeal. So the parts of the guidance that I'm going to take you to relate to that particular issue.
Yes, 235.
235, yes. And you'll see, my lords will see a heading, genuine vacancy definition. And you'll see that there are 3 bullet points. And I respectfully invite my lords to take a note of what the second bullet point says. That, in my respectful submission, is relevant when it comes to the question of construction of the word match as it appears subsequently. So genuine vacancy is one which, among others, does not include dissimilar or predominantly lower skilled duties. Predominantly is the word that I would respectfully highlight. So if a certificate is issued as a senior care worker and the person concerned is not performing that duty but is acting, say, as a manager or is doing another lower skilled job, then that wouldn't be a genuine vacancy. You then have examples on the next page, page 236, paragraph C 1.46. And you'll see that all 4 examples, one way or another, contemplate deliberate wrongdoing. Bullet point 1, the role that does not exist. It's entirely fabrication. Second, one which contains an exaggeration or incorrect job description, but that's not alone, to deliberately make it appear to meet the requirements, or is otherwise shame. Deliberate and shame are the word to emphasize. A job is created to enable someone, primarily to enable someone to come and stay in the UK. So finding of dishonesty or deliberate wrongdoing is needed so as to justify a conclusion that the vacancy is not genuine. The Secretary of
Well, that's
State.
of course. I mean, this is not a closed category, is it?
No, but it's common ground, my lord, that a finding of deliberate wrongdoing or dishonesty is needed before the Secretary of State concludes that a vacancy is not a genuine vacancy. So, for example, if there is incorrect job description, then that alone would not be sufficient unless that is deliberate. So if it's simply an administrative error, that would not be enough. So that is the definition of a genuine vacancy. If you then go to page 260 of this bundle, this is Annex C1, circumstances in which we will revoke your license. And my lords will see a long, lengthy list of the relevant circumstances. The two provisions that are relevant. The first is S, which appears at page 263. The role undertaken by a worker you have sponsored does not match one or both of the following. And a question that my lords will have to consider in resolving this, resolving ground two, additional ground two, is what is meaning of the word match. So my respectful submission is that what that word contemplates is not a sort of mathematical comparison between the job description that appears on the certificate of sponsorship and the job duties, but what is required is a holistic consideration of things as in real world.
Sorry, consideration of?
A holistic consideration of things as they stand in real world. So by that, I mean that if the certificate of sponsorship identifies or lists 10 duties, and if the employee concerned is performing 9 out of those 10 duties, but have not yet performed the 10th duty, that would not mean that there isn't a match. One must look at things globally to make an assessment. The second provision that is relevant is Z, which appears at page 264. And you will see that concerns genuine vacancy. And you have 3 bullet points as examples, again contemplating deliberate wrongdoing or dishonesty. A job does not exist, is a sham, or created mainly so the worker can apply for entry clearance. Now, Miss Rima was sponsored by SCL, and a certificate was issued to her. That certificate, my lords, is at page 107 of the bundle. Can I take you to that document before I show you the relevant decisions? So my lords will see that this is a document that sets out personal information relating to Ms. Rima, her address, travel details, etc. If you go to the next page, page 108, you'll see a heading work dates, and you'll see that the start date is 1st of March 2022, and the end date is 28th of February 2025. So Ms. Rima was employed for a period of 3 years, and she's required to work 39 hours a week. And you then have a heading towards the middle of that page, migrants employment. You'll see that the job title is senior caseworker, and you then have summary of job description. As the phrase says, it's only a summary, not a job description. And you'll then see the sort of duties that Ms. Rima is required to undertake during her employment over the period of 3 years. If you look at those duties, for example, if you just pick the last one, to escort residents as necessary. So if Ms. Rima is performing all these duties, but she hasn't yet escorted residents as necessary, that would not mean that the vacancy is not genuine or is dissimilar. Said in my respective submission, a holistic consideration is required. If you look at the next page, my lord, page 109, you'll see a letter which has a heading statement of facts, and this is a short statement by Ms. Rima. This was made following the receipt of the suspension decision. It was submitted to the Secretary of State with the submissions that I took you to. She says that she's a senior care worker, and she says that she's carrying out roles and responsibilities as per the contract and offer of employment letter. And she then says that my role as a senior care worker includes the following. And she has given sort of 7 examples. Yes, can I then just take you back to page 66 of the bundle? These were the submissions that were made following the suspension decision. If you look at page 67, you'll see a heading, the job duties as stated on Ms. Rima's COSR. And you'll see what is explained there, that Ms. Rima is in fact a senior care worker. She is performing the relevant duties. She has obtained a certificate in feeding training, which is relevant to a senior caseworker position. And a care worker would not, the submission said, would not undergo such a training. And there's then a reference to the statement that I've just shown you. If you then just look at the last paragraph on that page, the submissions dealt with the interviews, and the point made is that, well, if she was asked about her tasks, she would have explained her role as a senior care worker. Questions weren't put clearly to her. Page 68, you'll see that the submissions deal with the point that there is a mismatch between the job description as appears on the certificate and what Ms. Rima said in the interview. you'll see that it was emphasized again that she is actually a senior care worker. Secretary of State was assured that the duties on the certificate of sponsorship match those undertaken by Ms. Rima. And that was supported by the statement. The submissions then explain that essentially that there's really no point in SCL creating a vacancy that isn't genuine. This is dealt with at page 69. So the point that the Secretary of State was seeking to make was that, well, although Ms. Rima is employed as a senior care worker, she was actually performing the duties of a care worker as opposed to a senior care worker. And for that reason, there was a mismatch. Submissions make a point that, well, if the intention was simply to assist Ms. Rima, then the easier thing for SCL would have been to sponsor her in the category of a care worker. The role of both care worker and the senior care worker was in the shortage occupation list at the time. And this is the point that is made in the middle of paragraph, page 69. It was emphasized again that the vacancy is genuine. So these were the submissions that were made to the Secretary of State, and this was the evidence that was put to her. Now, the revocation decision, my lords, is in the core bundle. You have looked at that decision, but I'll take you to the initial part of that decision now. It's page 214 of the core bundle. Look at paragraph 5 of that decision. The job duties as stated on the certificate are, and then there are 8 bullet points. In my skeleton argument, I have numbered them as 1 to 8. So according to the certificate, Ms. Rima was required to perform 8 duties over the course of 3 years, from 2022 to 2025. The first bullet point, identifies Ms. Rima's primary duty, the primary duty being providing care. The Secretary of State takes no issue with that duty. There's no doubt that Ms. Rima is performing that duty. There is no doubt that the job exists. And the Secretary of State, in fact, takes no issue with any of these duties apart from duty 4 and duty 7. Fourth bullet point is to undertake some administrative duties. And bullet point 7 is to ensure that all resident care needs are catered for by the liaising team and manager.
And be responsible for shifts and rotas.
Yes. So the issue concerns those two items. If you look at paragraph 8, my lords, you'll see that this is where the Secretary of State says, it's actually a quote from the earlier decision, that the job role does not match with the duties which she states she is undertaking. So when she was interviewed, or when the decision was taken in 2023, Secretary of State's conclusion is that, well, she is undertaking those duties then. But as I pointed out earlier, so far as the job description on the certificate is concerned, what she was required to do was to undertake these 8 duties over the period of 3 years, as opposed to every single day of her employment.
Well, perhaps not every single day, but over the course of a year, one could reasonably expect that a senior care worker had carried out, as they put it on the next page, some senior or supervisory duties. That's the point they're making.
Yes, my just looking at paragraph 8, which of course is the starting point of the analysis. The first error, what in my respectful submission the Secretary of State made, was to make an assessment as things stood on that day, as opposed to just looking at things globally. And then
you won't be required to organise, to do something, every one of these things every day, will she?
Lord?
She won't be required to, or expected to do every one of these duties every day.
Or even in the first, in my respectful submission, in the first, say, 6 months or 1 year of the employment. And just taking the Secretary of State's case at its highest, if she has not yet performed the additional duties, that does not, in my respectful submission, means that the vacancy does not exist or the vacancy is shame. At its highest, it, in my respectful submission, demonstrates that she hasn't yet performed every single duty that appears on the job description.
We have to remember that neither this court nor the High Court was considering an appeal on the merits of this decision. The question is whether the Secretary of State was reasonably entitled to come to these conclusions on questions of fact, applying the policy that they do. Now, I can well understand your submission that they've misinterpreted the policy.
Yes.
That's an error of law.
Yes.
With which we are concerned. But simply to say, well, they shouldn't have come to the view that that there was no genuine vacancy because she hadn't yet performed some duties. I'm not sure that's really a question of interpretation.
No, and that's Lord, that's not the submission that I make. Right. The submission, Lord, that I make is that the Secretary of State misconstrued the policy. Right. So what they did effectively was to conduct a mathematical comparison between the job description and the job duties as stated in the interview. And what they did was that they picked 2 items out of the list of 8, and based on that, what in my respectful submission is a mathematical comparison, took the view that there wasn't a genuine vacancy.
Doesn't the nature of these 2 duties have some relevance to this analysis? Responsibility for care plans, rotas, shifts, liaising with team managers to ensure needs are met. That's I don't want to make a value judgment. That's of a different nature from delivering the specific care task, isn't it?
Yes,
it's not just 2 out of 8. It's 2 which are of a different nature in terms of the degree of responsibility, one might say.
Yes, I have no difficulty with that. My complaint, so as far as this point is concerned, is that it isn't a sort of mathematical comparison as what the Secretary of State has done. So you got to look at everything and then make a finding as to whether the vacancy is genuine or it isn't.
Why do you say it's a mathematical analysis?
Well, because what the Secretary of State did, in my respectful submission, is that she listed the job description from COS, and then paragraph 8, she picked 2 items of that list, and then essentially said that, because you're not performing those 2 duties out of 8, the vacancy is not genuine. Without, in my respectful submission, having regard to the overall picture and things as they are in real world.
Aren't those 2, looking at that, the bullet points, top of page 215, aren't the two that are picked out in paragraph 8 the ones which are associated with senior or supervisory duties? Those are the two distinctively supervisory aspects of the list, aren't they?
Lord, that, in my respective submission, is not what is obvious from the list. Of course, I mean, for example, the first bullet point relates to working with the team. If you are a senior care worker, then you'll effectively be leading the team.
I think the burden of that 7th bullet point may be the last clause, be responsible for shifts and rotas. I mean, that sounds pretty senior to me.
Yes.
Taking responsibility for producing shifts and rotas.
Yes, but yes.
And if she hasn't done that at all, yeah, at the moment, forgive me, Mr. Malik, I'm having difficulty in understanding how this is a submission about misinterpretation,
yes,
as opposed to misapplication of a policy. Now, in public law generally, we draw a distinction between misinterpretation of a policy and misapplication of it. If, for example, the Secretary of State simply doesn't understand the words,
yes,
doesn't understand what responsible means, or what senior means, or what a shift is, I could understand that would be an error of law because it's to do with the construction of a document. But you frequently get this in many public law contexts, like planning, that what's really being said is not that you didn't understand the meaning of the policy, but that you applied it in a way which you could not reasonably have done.
yes,
Because it's just not available to you.
yes.
But once you start complaining about application of a policy
Yes.
to the facts of a particular case, then at least to me it seems you're moving away from an error of law to an argument that it's irrational.
Yes.
But you're not saying that. You're saying this is an error of law, misinterpretation.
Lord, I make both points. I mean, this is my additional ground. One is about failure to ask the right question. Sorry, additional ground 2 is failure to ask the relevant question.
Yes.
If you look at additional ground 3, you'll see that the first point is misconstruction of policy.
Yes.
That the alternative submission is that, well, it's irrational and not adequately reasoned. So I do make both points.
But I mean, without labelling this point, the 7th bullet point, there are two essential responsibilities: to ensure that all needs are met, and the responsible for shifts and rotas. And the middle words of those, I think, are ways in which she must ensure that the needs are catered for. So, reading that carefully, one can see that it involves a degree of responsibility which the other roles don't have, I would suggest.
Yeah. I wouldn't disagree with that, my lord. I would accept that entirely. But her role as a senior care worker entailed these 8 duties. It wasn't simply, one particular duty. So if, for example, the certificate had simply said, well, bullet point 7, well, to ensure that the care needs are catered for. And if she wasn't performing that duty, the position might have been different. But as a senior care worker, she's required to perform all these duties. And it is, in my respective submission, an error of law to pick one particular duty out of 7, to compare it with the information that you received, and then to say that, well, there isn't a genuine vacancy because of one particular point. So that is the point that I make. Lord, if you then go to page 217 of the bundle, you'll see a heading consideration. And if you look at paragraph 15, there is a reference to Ms. Rima undergoing senior level training. including feeding, training, and there is a reference to the statement of facts, the document that you have seen. But the reason why the Secretary of State effectively rejects that evidence is set out at paragraph 17,
Yes.
which is that, there isn't any corroboration of the statement that you've made. That you haven't really substantiated your claims with the evidence.
Well, it's particularly, again, about the point that there's no evidence that she allocates shifts and rotas, nor any examples of the administrative duties she fulfills. So in other words, they're focusing, as my lord has said,
Yep.
on the two critical elements which might be thought to distinguish a senior care worker from any other care worker.
Yes. Now, if you look at paragraph 16, this is the summary of the statement of facts. You'll see that, she, among other things, stated that, she actually allocates shifts and rotas, and she liaises with the team managers, etc.
Yes.
Now, the Secretary of State can accept that, the Secretary of State can reject that.
Yes.
But what the Secretary of State, in my respective submission, cannot rationally do is to say that I'm not accepting it simply because it's not corroborated by further evidence, which is what, in my submission, the Secretary of State is doing at paragraph 17.
I agree that is what they're doing, but what I'm not sure about is why they can't lawfully do that. Because, I'm sorry, in the real world,
Yeah.
people sometimes do say things.
Yes.
And why isn't the Secretary of State entitled to say, well, I'd like some corroboration of that, please?
Well, the Secretary of State can say legitimately that, what you have said could be corroborated by documentary evidence. You haven't provided that documentary evidence, and therefore I reject the factual account that you have put forward.
Yeah.
That, of course, is not objectionable. But what the Secretary of State, in my submission, is really doing at paragraph 17 is making a different point. Is saying that, because there is no corroborative evidence, for that reason alone, there isn't a vacancy that is genuine. So, in other words, there isn't at paragraph 17 an outright rejection of the statement of facts. The Secretary of State is not saying that, you're lying, I don't accept your evidence. But the point is that there isn't corroborative evidence, and that is an error of law. If you then go to page 218, my lords, you'll see a reference to what was said in the interview, and a reference to a timesheet. And then you have the paragraph where you have the actual conclusion, and that you have failed to provide evidence to support your claim that Ms. Rima is fulfilling the range of duties outlined on her COS. That conclusion, in my submission, is one that wasn't open to the Secretary of State. So it was irrational for the Secretary of State to conclude that she wasn't fulfilling the range of the duties. The reasoning is that she wasn't taken at its highest, was fulfilling one or two of the 8 duties. There is then a conclusion that the vacancy is not genuine, but there is no finding of dishonesty. What is said is that, you have exaggerated things in order to facilitate her stay in the UK. Now, it's common ground that a finding of dishonesty is needed to justify a conclusion that the vacancy is not genuine. But you don't have that finding in the decision. The Secretary of State failed to ask herself the correct question. The question that the Secretary of State should have asked herself is there dishonesty on part of the employer or Ms. Rima?
Where do you say precisely that should be in this document? Where should it be in this? What size point is it omitted?
Well, that you are dishonest. The SCL is dishonest.
At which point, where should it be? Where should it feature in the analysis?
Well, after paragraph 23, so you'll see 22 and 23 are references to the policy guidance.
Yeah, I see.
There should have been a paragraph 24 saying that, well, I have considered whether you're dishonest, but I believe that you are. This job is a sham.
Yes.
It's created.
Mr. Malik, does it come down to this, that what the Secretary of State said in this letter was, we're not satisfied that Ms. Rima was actually performing the full range of duties
Yes.
which her job description said that she would be performing. But then never asked the next question, which is that state of affairs one that arose because of dishonesty on the part of the employer, the sponsor?
Yeah, that's the point.
That link is missing.
That's the submission. Yeah.
They leapt straight from the fact that she wasn't, in fact, performing the duties. And let's take, despite your earlier submission,
Yes.
let's just take it that they were entitled
Yes.
to reach those conclusions of fact. I think this ground is independent, isn't it? That you would still say there's an error of law in this reasoning because they've simply gone from that to the conclusion that it's not a genuine vacancy.
Yes.
Whereas it could be that there are reasons short of dishonesty or sham
Yeah.
why this state of affairs has arisen.
That is the submission, and I regret making my submissions in this manner. That the plan obviously was to make that point as the first point when it comes to grounds 2 and 3, additional grounds 2 and 3. Of course, because of the limitations of the time, I thought it was more efficient to just go through the decision letter and to make submissions as I was going. But my real, of course, this is additional ground 2 is that.
No, that's fine. There's no need to apologise. I should, however, note that you have 3 minutes to complete your submission.
Thank you. So the point that is taken against me is that, well, implicit in paragraph 21 is a finding of dishonesty. This is, of course, a finding of dishonesty is a serious finding. You know that from Balaji Gari, it has extremely grave consequences for migrants, for sponsors, for a registered social worker, someone who is providing care to vulnerable adults. So if the Secretary of State is alleging dishonesty, that should be made clear. But the word that is used is that, well, you have exaggerated things in order to facilitate her stay in the UK. But when I showed you the relevant part of the guidance, an exaggeration isn't enough. The exaggeration must be deliberate. So it's possible for someone to exaggerate things without appreciating that exaggeration would is objectionable.
But exaggeration is qualified. Phrase in order to facilitate her stay in the UK.
Deliberately.
I think the Secretary of State's point is looked at that as a whole.
Yes.
It's clear that is dishonesty.
Yes.
Not genuine and exaggerated in order to facilitate the stay.
Yeah.
That, she says, dishonesty.
But you say
But the submission is that she hasn't. Yes.
Yeah, and you say there was no reason for the sponsor
Yes.
to do that because they could easily have facilitated her entry to the UK simply by calling her a care worker.
Yes. That's the submission. Yes. Yes. Lords, you have my skeleton argument. I hope that document makes these points in a rather structured manner. But of course, the final point that I made is one that I made at the outset of my additional ground 2. And of course, then you have misconstruction of policy, and the last point is the rationality challenge. Lord, I have a minute or 2 left. Can I just very quickly show you the judge's judgment and just show you what the judge has said on those grounds? So co-bundle page 116 and 117.
Yes.
paragraph 30, you'll see that the Secretary of State submitted that the paragraph that I've shown you is an implied finding of dishonesty, and the judge agreed with that, and in my submission erred in doing so. As paragraph 35, the judge says that the Secretary of State has not failed to ask herself the correct question. In my respective submission, she has.
Are you going to mention 34?
Yeah.
Relevant to your last point we were discussing.
Yes. Well, paragraph 34, the judge seems to justify his ultimate conclusion that there is a finding of dishonesty. But you have my submission that there isn't one. Paragraph 43 is the last paragraph that I'll take you to. This is where the judge deals with the word match, paragraphs 34 and 35. I've dealt with those points already. So match has a broader broader meaning.
Yeah.
I'll just take one second. Lord, I'm very grateful. I think I have made points that.
We're very good. Thank you very much. Now, the timetable allows you to have 15 minutes if you need them for
my Lord,
additional submissions.
I was going to say, I mean, the reason for that was it was recognised that there was a potential issue that arose because of the overlap between the two appeals, and that things might be said that I needed to respond to. So far, I have no issues, so I was going to stand up just to explain that. Obviously, there is a possibility something could arise, but so far nothing has arisen in relation to my appeals. Can I, though, use 1 minute of the time to draw attention to two things that I think, because of my duty to the court, I need to draw attention to? The first is, I think certainly my learned junior has said, and he has a better record because I was on my feet, I think I said that following Al-Fayed, there was a minded to refuse procedure. To be clear, I think that was quite a lot of people's understanding, but in a SIAC decision that I wasn't aware of, called KU, which is SN 97/2023, it's paragraph 12, apparently the Home Office filed evidence saying they only followed the Al-Fayed procedure in rare cases following the decision. I don't think anything turns on it, but I think it's important to correct that if given what I may have said, I think, according to my junior.
Yeah, thank you. That's helpful.
The second thing that I've stood to raise is that my learned friend, Mr. Malik, said that it's common ground that where it said there's, if I hadn't heard his submission correctly, that where it said a job isn't genuine, that implies dishonesty. Now, on the facts of the case, that may be a clear implication, and because of the particular circumstances. But I think, given that submission, I ought to draw the attention of the court to the fact that there is a Court of Session decision, outer house, called Experience India, which is 2016 CSOH 161 at paragraphs 12 and 14, that says actually a mere finding that a job isn't genuine doesn't automatically imply dishonesty. I think, given my awareness, I think of that judgment, given what was said, I think I probably am obliged to draw that to your attention. Again, it's not for me to say where that takes anyone, but
No. What was the case in name again?
Experience India. It's 12 and 14, I think, from having looked together.
Thank you very much.
Just very quickly, may I just invite the court to decide the appeal on the basis of how it was argued below. So this is paragraph 27 of the judge's judgment. The Secretary of State submitted that, it's dishonesty decision that we have taken. So that is the basis on which I invite the court to decide the appeal.
Thank you. Right. Now, are we going to hear from Mr. Hill next?
Well, we're in your hands. I think the programme was for you to hear from me
Oh, sorry.
on the main issue, and then Mr.
I got
Hill
the
on
timetable wrong.
the additional grounds.
Yes, sorry, yes. You have half an hour to reply in
Yes.
supporting Care,
Yes.
excluding what's been called the cross appeal,
Yes.
but is in fact respondent's notice point.
It is, well, that was my shorthand in our
No,
skeleton.
I understood what you meant.
Yes. I think I will, in fact, be less than half an hour, but Mr. Hill may need slightly longer. But to deal with the points of reply on the main issue. So first, Mr. Malik began by emphasising that there were 192 workers, of whom over 60 came under the sponsorship scheme, and this was a single employee. But I would remind the court of the point I made yesterday, that there were 6 that were interviewed. That's the sample size. The second point relates to the issue raised this morning as to the Secretary of State's power to create this scheme. And Lord, I thought it was possibly slightly unfair on me to say that it was my case that it came under the general power. The Secretary of State didn't advance any particular case, but in answer to a question yesterday, I pointed to paragraph 27, but having looked at it further, and in particular seen the wording in 28, it's clear that Lord Sumption is saying it comes from the Immigration Act, which provision, respectfully, seems unclear. Lord Carnworth, in his judgment, assumes it emanates from Section 1, but leaves open the possibility of Section 3. I'm not sure how that helps Mr. Malik's case in any event. Insofar as it's relevant at all, our submission would be if it does come from a specific statutory power, whether that's Section 1 or Section 3 of the Immigration Act, that rather assists our point that it indicates the narrowness of the duty of the Secretary of State. The third point that I make, it relates to the evidence that you were shown about impact, which is from Mr. Taher. The relevance of that statement in my submission is unclear, because it postdates the decision in question. It came after the decision. So in the Prestwick appeal, Mr. Southey relies on statements that came after the decision, and he says, well, in his appeal, the point is this is unfair, and if we'd had a fair procedure, this is what we would have said. The complaint in supporting Care is not of unfairness. The judge's point in paragraph 55 is not about fairness. It's saying that this is an inadequately reasoned decision. So I'm not sure why post-dated evidence is relevant in supporting Care. You were then shown, my fourth point, a letter. I think it's at page 68 of the supplemental bundle. I would ask you to look at that. The letter begins at 66, and then it's 68 to 69. I appreciate this is something of a two-edged sword, as was pointed out in argument, but the Secretary of State's position is matters of impact were not raised. That's been our consistent submission, whereas Mr. Malik's submission is, well, they were raised, look at this letter. And despite his observations on this letter, we don't accept that it raised issues of impact. At page 69, the two passages on which he relies, it is right to say that it highlights the number of employees, and it's right to say that care worker and senior care worker positions are on the shortage occupation list and are difficult to fill. Just pausing there, that's not a submission about impact. That's not saying if you revoke our licence, we won't be able to operate or we will reduce the number of residents. It's just saying it's difficult to fill these positions. The second point that he makes on that page is at the bottom, paragraph 12, and a point that was covered in argument is that, firstly, this is a response to the specific breach. So the point at issue here is whether there were reasonable grounds to believe that the role was not genuine, and they're responding to say, well, it was genuine. But the point they're making in that second sentence, without these roles, the organisation would be unable to support the 210 people, is saying, well, they're genuine because we really need people carrying out these senior positions. I don't think it's fair to read that paragraph as saying we won't be able to support the people if you revoke our licence.
Sorry, you don't read the last sentence, two sentences of 69, saying they wouldn't be able to support.
If the licence is revoked, it's saying we won't be able to support the 210 people without those roles. Oh Lord, if you look at the bit in italics that they're answering, this on the second line, after the colon, it says we have reasonable grounds to believe the role, and I've highlighted that on mine, for which you have assigned a COS is not genuine. So the concern that's being raised is this is not a genuine role. And part of the answer is to that is to say, well, it is genuine because we do need people in this more senior position. I think it was fairly accepted by Mr. Malik that it's not a submission in that letter on this will happen if you revoke our licence. It was certainly at best a response to that specific point. My fifth point, the use of template or standard wording, I would agree with and adopt. My Lord suggested that there's nothing wrong with using standard wording, if that addresses similar issues in similar ways. And indeed, there are merits in doing so. And I just highlight, without going to its paragraph, 128 of New Hope, where I think it was Mr. Malik made the same criticism, and the judge rejected that as being, quote, unjustified and unfair, and we would endorse that. And sixthly, the first instance decision in New London. This came about because I'd made the submission that if one looks at the cases that were found to be procedurally unfair, they seemed to be based on cases where the guidance had not in fact been followed properly. And this was said to be an example of a case where that was not the case. It is right to say that at paragraph 60, Mr. Justice Wynne Williams says that the fact that something is in accordance with the guidance does not necessarily mean it's lawful. And we accept that as a proposition. But on my reading of this case, it appears, in fact, he found that it was not in accordance with the guidance. Perhaps we'll just take a brief moment to look at that. He says in paragraph 58, I appreciate, of course, under the guidance in force at the time the decision was taken to suspend the licence, UKBA had to be satisfied the licensee was seriously breaching its duties and was posing a major threat to immigration control before it could suspend the licence. And in paragraph 61, the judge said, I do not accept that there was information or evidence before Mr. Cram which reasonably justified the conclusion that the claimant was in serious breach of its sponsor duties and posed a major threat to immigration control. and then at 62, he repeats the same point. So in my submission, it is in fact another example of where the guidance was not followed appropriately by the Secretary of State. And the New Hope case, which I think someone else, I can't remember if it was Mr. Southey or Mr. Malik earlier today, said was another example, is in fact it says in terms in that case as well that he doesn't accept the submission that the guidance was followed appropriately. There may be cases, I can't say there aren't, but of the cases we've been shown where there's a procedural breach, the courts appear to have been critical of the way that the guidance has been applied rather than applying additional criteria.
Can we just go back, if you don't mind, Mr. Mancock, to Mr. Justice Wynne Williams' judgment in New London at paragraph 60? Because this may or may not be important in other cases, and we need to make sure that anything we say about the law is accurate and doesn't perhaps give rise to hostages to fortune in the future. Just as a matter of first principle, sometimes, of course, an administrative decision-making body will have no express procedure whatsoever.
Yes.
In which case, the common law has nothing to guide it. It just has to say what a fair procedure requires. But where a public authority has actually thought about what process is appropriate given the nature and scope of its decision-making function, and for example, it's let's take, for example, the time limit for giving representations. It says 20 days. If there were nothing expressly there, the common law might have to say within a reasonable time or something of that sort. I don't know. We might say 14 days. Or we might say 3 months. I don't know. But isn't it, at least as a starting point, the law that where there is an express procedure which has been laid down, that unless that's challenged as being unfair, that at least normally the public authority is entitled to follow that process. Now, there may be residual cases, to use that word again, because you can never shut your mind to anything. You may still have to consider whether something else is required. So normally it's going to be in writing only. But it might be that in some case the common law says, well, actually an oral hearing is required. But I'm struggling here a little bit. I think I do need some help, because we may have to say something about whether what the principle is, where you do have an express procedure. And you're not going so far as to say, and I can understand why, that if there's an express procedure and we followed it, that's the end of it. You're not saying that, and that's a very fair stance for the government to take, if I may say so. But what I am wondering is whether at least it provides some kind of framework which guides the courts as to what will normally be taken to be a fair procedure.
I would agree entirely with what my Lord has said, that where there is, in particular as here, quite a detailed procedure that, as you say, has been thought through and is there, and those who voluntarily agree to this, to be in this scheme, know what it is. At the very least, the starting point, if not the presumption, is that if that scheme is followed, it should be fair. And I would submit that in terms of justifying that through administrative law principles, one can just look at duty, or in this particular context, for example, what Alison Foster said in Gold Care, that when you're deciding what's fair, you have to look at the context. And the specific provisions in this scheme, which has been designed, are that they're the most relevant context. So does that help, my Lord?
It does help, yes, thank you. Right, now where are you going next?
So I have one final point, which is just on the issue of genuine vacancy. And my Lord, it is important, but it may not be important in supporting care, but it is very important generally. So it is not common ground that genuine vacancy generally requires dishonesty. It is common ground that there was an allegation of dishonesty in supporting Care's case, and it is common ground that the allegation that there was a deliberate exaggeration is an allegation of dishonesty. But there are, in supporting Care's case, there are two parts of Annex 1 that are breached, C1S and C1Z. C1Z requires the dishonesty finding. C1S does not. Prestwick is an example. The 5 employees, and it was eventually accepted, were not working in accordance with their job descriptions. There was no allegation of dishonesty in Prestwick. So it is right to say that it's common ground that supporting Care is a dishonesty case, but it is not right and would be unhelpful with respect if it was suggested in the judgment that findings under the genuine vacancy heading, including C1S breaches, require dishonesty, because they don't.
That's helpful clarification. Thank you.
Lord, unless there's anything else on that point, I will hand over.
Thank you very much. Yes. Now, Mr. Hill. I think according to the timetable, Mr. Hill, given that Mr. Sudley didn't take his full 15 minutes, I think you have about an hour.
I'm grateful.
If you need it.
If I need it. My Lord, I will be dealing only with the additional points raised by the respondent. I will consider each in turn, beginning with the first additional point, which is the procedural fairness challenge. I'm going to start by considering what the authorities require, and then address whether the guidance and the approach of the Secretary of State in this case meets those requirements. In terms of the authorities, the leading authority, we say, on this matter, where audi alteram partem applies, is ex parte duty, which has been referred to, but we haven't gone to the full measure of it. I would invite you to turn to page 259 of the authorities bundle, which is volume 1. This is Lord Sumption quoting the relevant passage from Doody in the Bank Mellet case, but it is Doody that is of interest here.
Yes.
You can see it begins at paragraph 30. I would invite your lordships to read through the 6 elements there from Doody. My lords, the reasons that I say that this is the central authority is it is cited in all of the other relevant authorities to which you've been referred. And I can provide the paragraph numbers if required, but it is there in Bank Mellet, it is in Pathan, it is in Balajagaria, it's in Gold Care, New Hope Care, Tender Care, London Reading College, Taste of India, Mushtaq, Anjum, and the first instance decision at New London College.
This may be something, Mr. Hill, you're going to return to, so don't take it out of order, please. But Lord Mustill's 4th point, where he talks about an essential feature of the context, is the statute. Does that have to be adapted to a context like the present, where we don't really have a statutory, well, we do have a statute, but it's the Immigration Act. What we're really talking about is a policy which sets out what the nature and scope of the decision-making function is. Is that a proper way of looking at limb 4?
My lord, we say yes, it is,
Right.
and we say that is precisely what Alison Foster QC, as she then was doing in Gold Care at paragraph 36, and it is notable that at paragraph 36 of Gold Care,
Sorry, can I just make a note of that reference? Gold Care.
36,
and which-
851 of the authorities bundle.
Page 5.
851.
8851, sorry.
Volume
Bundle 2 then. Yeah.
Should we look at that?
If you would do so, my lords, you've been taken to it before. The point that I would note in it
Yes, I recall now. I think I made an observation that this was helpful yesterday.
Indeed, my lord, you did. I would point out that duty is cited as one of the authorities there.
Yes.
And what Alison Foster QC said at the time is that procedural propriety depends on the subject matter of the decision, the executive functions of the decision maker, the particular circumstances in which the decision made, and also that what fairness requires depends on the character of the decision-making body, the kind of decision it has to make, and the statutory or other framework in which it operates. Gold Care was a Tier 4 case, and this is, we say, Alison Foster QC adapting what is said by Lord Mustill in duty to those circumstances. And principles 3 and 4 of duty are about the fact that procedural fairness is context specific. You have that point. You've heard it made by Mr. Magdalen. I won't repeat it, but the context is clearly the context of the Tier 4 scheme, the guidance, and the principles as set out in London St Andrews College, which you've heard much about. We say those principles apply to procedural fairness as well as the substantive decisions, and you've heard Mr. Magdalen on that in those submissions. Going back to duty in principles 5 and 6, if I could ask you to turn back to that at page 259 of volume 1. This, we say, is the crux of what procedural fairness requires in cases such as these. And it's 3 things. First, that the person affected must know the gist of the case which he has to answer. Second, that that person be given an opportunity to make representations. Third, have those representations taken into account when making or modifying a decision. That, we say, is a simple, practical statement of what is required. There is no need for consideration of heightened procedures or any other elaboration. That is what is required. And it is the Secretary of State's case that the system provided for in the guidance and applied in supporting Care's case met those requirements. The first stage of that system is the interview and inspection, which allows for information to be obtained. The second stage is the suspension letter, which is informed by that information and which sets out the gist of the case that the sponsor will have to answer. But, and this is critical given the way that the case has been put in supporting Care, it is not the decision. The next stage is that the sponsor then has 20 days to make representation, 20 working days. Then the final stage, those representations are considered before a decision on revocation is made. I understand from Mr. Malik Casey's submissions that he accepts that if that is right, then there is no procedural fairness ground in this case. If that was done. I add here that there is nothing in ex parte due date, any of the other cases before you, that supports the proposition that fairness requires a second interview or some form of oral hearing. That was advanced in the skeleton argument. Mr. Malik KC appears to have presented the case differently orally by saying that it had been sufficient if notice was given by letter, which is what happened. Turning to the guidance and how that complies with the duty principles. You went to this yesterday, so I will go briefly to it if I may. Supplementary bundle, page 253. This is section C9, suspending your license. We could if we could go, please, to C9.9, the process we will follow. Mr. Mangle took you to this, albeit in the guidance in Prestwick, but the same principles apply here and the same wording applies. C9.9 states that where the Secretary of State is satisfied that they have enough evidence to suspend the licence, they will do so and will write to you giving reasons for the suspension. C9.10 states that they will inform the sponsor of the investigation, give initial reasons for the suspension, and allow for written statements of evidence. C9.11 sets out the 20 working days that they have to respond. It states this is your opportunity to seek a review of our decision and set out any mitigating arguments you believe exist. Your response to us must be in writing and set out with any relevant supporting evidence which grounds you believe to be incorrect and why. We may give you more time to respond if we are satisfied there are exceptional circumstances. We will not hold an oral hearing. A point relevant to the skeleton argument, but no proceeding.
Can we just pause on that for a slightly different point, if you don't mind just helping me with this? It's a point I raised with Mr. Mankton. Yeah, if it had said the opposite, if it said we will hold an hearing, we will hold an oral hearing, I can well understand an argument from someone who's denied an oral hearing that I've been treated unfairly because an express procedural requirement which you said you would follow has not been followed. Even in circumstances where the common law would not necessarily have given you the right to an oral hearing. So I can see how, in that situation, it might actually be beneficial to an individual to be able to say, well, I rely on the fair procedures set out expressly by you. And that's why I'm just trying to feel my way on what the correct legal framework here is. That if it's the other way round, where it says we will not hold an oral hearing, is the position simply left at large so that anyone can come along to the court and say, well, I know it says that, but I'm still going to insist that there is an oral hearing required? Or does the common law at least start from the position, well, there may be an oral hearing required because of the circumstances of a particular case, but normally the decision maker is entitled to follow its own procedure. It's not obviously unfair.
My lord, that it would be our submission. It starts from that position.
Right.
In terms of what the common law requires, I'll come on to it shortly, if I may, with Balajigari. But in terms of duty, what was said at 6 is or at 5 and 6, the language, I say, is important in terms of what the common law requires, because it is caveat. It's fairness will very often require that a person who may be adversely affected will have an opportunity to make representation. And 6 is since the person usually cannot make worthwhile representations without knowing what factors may weigh against his interests. Fairness will very often require that he is informed of the case in which he has to answer. So these are not hard and fast rules. There is a space for adaptation when adapting the common law. Perhaps it may help to go straight then to Balajigari, where it deals with paragraphs 55 and 56, which is at 144 of the authorities bundle. In case your lordship will know well.
Is that volume 1?
Volume 1. Yeah, thank you. Paragraph 54, which Mr. Malik took you to earlier.
Yes, thank you.
Referring to the
Yes.
ex parte Al Fayed case and the introduction of a minded to refuse procedure afterwards, which notably and critically was not present in Balajigari. At 55, the court finds for all of those reasons we have come to the conclusion that where the Secretary of State is minded to refuse indefinite leave to remain on the basis of paragraph 3225, on the basis of the applicant's dishonesty or other reprehensible conduct, he is required as a matter of procedural fairness to indicate clearly to the applicant that he has that suspicion, to give the applicant an opportunity to respond, both as regards to the conduct itself and as regards any other reasons relied on, as regards undesirability, an exercise of a second stage assessment, and then to take that response into account before drawing the conclusion. So those, we say, are the three elements of duty applied in the particular context of a decision on indefinite leave to remain when there is an income discrepancy. Then going on to the next paragraph, 56, which comes to your lordship's point about a guidance which doesn't include a provision for an oral hearing. We do not consider that an interview is necessary in all cases. The Secretary of State's own rules give a discretion to him to hold such an interview. However, that duty to act fairly does not, in our view, require the discretion to be exercised in all cases. A written procedure may well suffice in most cases. And that, we say, is this court taking duty, applying it to the facts of that case, noting that there is a discretion that may not always be necessary to be used, but finding that the situation that had been in place before this decision did not comply with duty because it did not have all of those stages met.
Yes, and you're probably going to come back to this, but on the following page, we did address the Secretary of State's argument in that case that it would suffice to have post-decision fairness, and in particular an administrative review, but we rejected that in that particular context.
Yes.
But I think your submission is that that's materially different from the present context, because the point we were making there about people tending in good faith to be defensive is where they've reached a final decision, whereas here the Secretary of State expressly has a procedure by which he does not reach a final decision until after people have had the opportunity to make representations.
That's precisely my submission. I would merely point you to paragraph 44 of the judgment of the court,
Yes.
in which it is stated that it was crucial to the context of the decision that there was not a minded to procedure. And as you say, the Secretary of State sought to argue at 58 that was not necessary, and the court rejected that argument. But in contrast, here, supporting care did have the equivalent of a minded to procedure, which is the suspension letter.
What Mr. Malik says about that is that in Balajigari we said it's enough that there's a suspicion, whereas here he says that the suspension notice doesn't say suspicion, it says this is what I believe. And he says, therefore, basically, you've already made a finding of dishonesty, and so it's too late to be giving us a chance to make representations after the event. What's the answer to that?
I have 2 points on that, my lord. One is a point on construction, and one is a point on fact. If I may start with a point on construction, the first element of this is that the suspension letter must be read in the context of the guidance.
C9.1.
C9.1, and as Mr. Mangnall took you to yesterday in the Prestwick case, it's at page 51 of the supplemental bundle. In the supplementary care case, supporting care case, it's at page 224. And that is the preamble to part 3. Which states, in terms, I've said 224, it may actually be a bit further on, forgive me, Lord. 225, you must read everything, is the point.
Well, the phrase believe comes in C9.1.
I'm grateful for that, my lord. I may.
Overview.
My lord, C9.1, if we believe that you are breaching your sponsor duties and or pose a threat to immigration control or are engaged in behaviours or actions that are not conducive to the public good, we may suspend your licence. It's in section C9, suspending your licence.
Mr. Mallett's case is the way the word believe was used in the letter indicated and mine was made up. I hope I don't. He nods, so I think I've got his submission right. What's your submission on that?
That the word believe should be given the alternative interpretation that your lordship gave to it, or invited us to accept could be given to it, which is that it is a word that is used to indicate suspicion. It is a word that does not show a closed mind, and read within the context of the guidance, and at C9.1, it is clear that it is part of the process of the suspension element, not the revocation decision.
I'm not sure, you may be right, I'm not sure you need to go that far. I mean, it's well established in, I think, in criminal procedure that the word belief is distinct from the word suspicion. I seem to recall there's an old Privy Council case where Lord Devlin makes that point, I think. But I'm not sure that that's really at the heart of your submission. I think what you're saying, and this is really what my lord was putting in argument earlier, is that if you emphasise the word belief when you read that sentence, what's being said is we haven't made any findings of fact. We currently believe, our opinion is that on what we currently know, this is what we think, this is what we believe, but this is your opportunity to tell us anything that you would like to say. So in other words, there may be these are gradations. Belief may be something slightly stronger than a mere suspicion, but I'm not sure that matters to this analysis, because the fundamental point is that this is not a final decision, and we want to hear what you've got to say before we make a final decision.
My lord, I cannot improve upon that. That is our position.
Okay.
And the other phrase that might be relevant is, in that context, is while we make further inquiries at the end of 9.31.
Indeed, the whole of that.
That's the point of the further inquiries. It might be asked if you've already made up your mind.
Quite so, my lord. And that is what the whole of that section of the guidance says. This is a part of the investigatory process. We have not arrived at a final decision. You will have an opportunity to make representations. That is, we say, consistent with duty. If we go to the letter itself, at page 56 of the supplementary bundle, the first point to make from the first page of the letter is that it is subheaded suspension from a register of licensed sponsors. It is clearly a suspension letter, as envisaged by the terms of the guidance. And then, just forgive me. 56.
Thank you so much. In supplemental.
just taking you through very briefly the way the letter is set out. You have the general sponsor duties, the concerns of a reference to what is stated on Ms. Reamer's COS. That's at 3. And at 5, there is the evidential crux that the Secretary of State is identifying as a problem, which is that during the interview, Ms. Reamer did not say that is what she was doing. Then 6 expressly states this is the problem that we are concerned about. 7 goes on to say, and it's important to read the whole of paragraph 7, Ms. Reamer and Ms. Karim are employed as senior carers. However, from their interviews, it is clear that they are not undertaking any senior or supervisory duties. So it is not a decision that has been arrived at with the Secretary of State saying it is clear that they are not doing this. It is saying, given the evidence we have from the interview, it's clear that they're not doing that. Is there any other evidence that you wish to bring to our attention? We can see later in the letter at 46, the next steps section, which is at page 64 of the bundle. There is the word again, we believe that the issues described above constitute a failure to comply with your sponsor duties. To give you the opportunity to explain the above issues before we begin revocation action, we've suspended your licence, you have 20 working days, etc., etc. So this is the opportunity to bring to the Secretary of State information beyond the interview. And it is, we say, clear on the proper construction of that letter in the context of the guidance that this is not a final decision that has been arrived at. Instead, it is the second stage of a duty process, given an opportunity to make representation. My Lords, I would only add to that the observation from Justice Garnham in the case of Guarani, which is not in your bundles, that an open mind is not necessarily an empty one. That's the point of construction. That is the point of construction. The point of fact, if I may take you back to paragraphs 4 and 5 of the suspension letter. We can see there that the complaint is about not just Ms. Reamer, but also somebody identified here as Ms. Karim. And it's exactly the same complaint that their COS lists all of those duties, and in the interview they don't say that they are doing them, and then that has given rise to the Secretary of State's concern. If we then turn to the revocation letter, which is at core bundle page 217, under the heading consideration, paragraphs 13 and 14.
Sorry, can you just give me a second to catch up with you?
I'm sorry.
Bundle page
217, core bundle.
Yes, thank you very much.
At paragraphs 13 and 14, the Secretary of State, having considered the representations that have been made following the suspension letter, finds that there has been an error that the Secretary of State has made, and that what was thought to be a problem with Ms. Karim actually refers to Mr. Resvi, but Mr. Resvi is employed as a care worker, and therefore what Mr. Resvi said in his interview is entirely consistent with that, being a care worker, Therefore, Mr. Bresby's role as part of a revocation decision disappears. Secretary of State has kept an open mind, has considered the representations, and therefore the concerns that have been raised have been answered. We say that is a factual point which demonstrates that the suspension letter was not a final decision, but was a genuine minded to procedure. My Lord, that would seem to dispose of a procedural fairness ground. I would merely make two brief further points. The first is that matters that were not put in the interview of Ms. Reamer and Mr. De Heer were put in the suspension letter. I won't take you back to the suspension letter, but you will see that it has informed the sponsor of the gist of the case against it and allowed for representations to be made. And it seems that Mr. Malik has accepted now, but it's sufficient to do that with a letter, doesn't require a second interview. The second point I would make is in response to Mr. Malik's submission that if relevant questions had been put during the interview, then all of the evidence that was given in July 2023 and the 8 witness statements that were provided then, all of that could have been provided to the Secretary of State before the suspension letter. Two quick points on that. The first is that those statements could have been provided in response to the suspension letter before the decision was made. Had they been provided, they would have been taken into account. There was nothing stopping Supporting Care from providing that information. And indeed, it was expressly requested by the Secretary of State in order to help explain what Ms. Reamer's role was. The second point on that, and it's in paragraph 50 of my skeleton, the references are there, is that there is nothing in those statements that actually assists Supporting Care, because those statements do not say that Ms. Reamer was undertaking administrative duties such as care plans, or that she was responsible for shifts and notice. And those are matters I will come on to later. My Lord, that is all I propose to say on the procedural fairness point. The other two grounds of challenge are a challenge about the dishonesty finding and a challenge about misunderstanding the guidance. The dishonesty challenge relates solely to CS1Z, the reason given at CS1Z for revocation, which is the not having having an exaggerated or incorrect job description. The other ground, the third ground, applies to both CS1Z, but particularly to CS1S, which is the mismatch between the actual job and the job description. But turning first then to the challenge on dishonesty, we say that the way that the case has now been put discloses three elements of the challenge. There are two errors of law, and then possibly a rationality challenge as well. The first error of law, which Mr. Malik has identified and which he emphasised in his oral submissions, is that the Secretary of State did not apply her mind to the correct question. In other words, whether the alleged exaggeration was dishonest. The judge below, paragraph 30, that's at Core Bundle 116, I don't ask you to go to it, but you'll note it's there. The judge held that that was not correct and that a proper construction of the decision letter is that Ms. Reamer's role did not represent a genuine vacancy, had been deliberately exaggerated, and that this amounted to a finding of dishonesty. And as Mr. Magnan has said, that is the basis on which the Secretary of State rests its case. We say, if you look at the decision, that is plainly correct. And I will take you to the relevant passages, if I may. It begins at Core Bundle 214. At paragraphs 5 and 7, there is a recitation of what was said in the suspension letter about the Secretary of State's concerns. And I've taken you to those in the suspension letter, that there is a disconnect between the job description and how Ms. Reamer described her job in the interview. Paragraph 9, there is the section of the suspension letter, still at that stage referring to both Ms. Reamer and Ms. Kareem, and the Secretary of State saying that she was not satisfied that the role of senior carer undertaken by Ms. Reamer represent genuine vacancies. And then, critically, there is reference to the relevant parts of the guidance. You can see it 10 to 12, paragraph C1.38, C1.44, and at 12, C1.46. Those parts of the guidance are reproduced, and at 12 we can see the examples of vacancies that are not considered to be genuine include, but are not limited to, and there are the 4 bullet points that Mr. Mallet referred to earlier, and he rightly said each one of those contains an element of dishonesty. It is the second point that is relevant in this case, that the job, the role is exaggerated or incorrect job description to deliberately make it appear to meet the requirements of the route, which it does not or is otherwise a sham. So the Secretary of State has included that guidance, which includes the dishonesty point. Then turns to a recitation of the submissions that have been made by the sponsor, by Prestwick Care, paragraph 15. At 16, it refers to the statement of facts provided by Ms. Reamer, and there it is stated, last 2 bullet points, that she does undertake some administrative duties and does allocate shifts and rotas. At this stage, the Secretary of State is therefore left with a stark contrast. In her interview, she did not say that she did this. It is now asserted that she did do this. The Secretary of State, therefore, at 17, looks to what evidence has been provided in support of that assertion and finds that there hasn't been any evidence which supports it. At 19, the Secretary of State goes back to the interview and shows that Ms. Reamer was asked what position she holds and what she does day to day. And then at 21, this is the paragraph that is criticised, it seems, but the Secretary of State finds you have failed to provide evidence to support your claim that Ms. Reamer is fulfilling the full range of duties outlined on her COS. We continue to believe that the role of senior carer undertaken by Ms. Reamer does not represent a genuine vacancy within your organisation and has been exaggerated in order to facilitate her stay in the UK. Therefore, this issue has not been addressed. That is followed at 23 by reference to the mandatory ground for revocation, C1Z. The second bullet point refers to an exaggerated or incorrect job description to deliberately make it appear to meet the requirements of a route. We say, when read in the round, as the judge did at first instance, this clearly demonstrates that dishonesty was in the Secretary of State's mind. Indeed, if the word deliberately had been included at paragraph 21, then there would be absolutely no basis for pushing for this element. We say to criticise the decision for the absence of one word in one paragraph when there is clear reference to the guidance and to the dishonesty element of the guidance, we say that would be an overly legalistic reading. That, my lord, is the point that we make in terms of the first error of law, that the Secretary of State did not turn her mind to dishonesty. We say plainly she did. The second error of law is an argument about the reversal of the standard of proof. I will take this briefly, if I may, by going back to Balajigari, which is the authority cited in support, and to paragraph 42. That is at page 140 of the Authorities Bundle, Volume 1. This is also cited by the judge below. 42 says that my lords, it says there, and this is obviously in the context of a discrepancy in earnings cases, that the discrepancy may justifiably give rise to a suspicion that it is the result of dishonesty, but it does not by itself justify a conclusion to that effect. What it does call for is an explanation. If an explanation once sought is not forthcoming, or is unconvincing, my emphasis, it may, at that point, be legitimate for the Secretary of State to infer dishonesty. But even in that case, the position is not that there is a legal burden on the applicant to disprove dishonesty. The Secretary of State must simply decide, considering the discrepancy in light of the explanation or lack of it, whether he is satisfied that the applicant has been dishonest. We say that is precisely what has happened here. There is something that calls for an explanation. Per duty, the sponsor has been put on notice of the need for that explanation, and the evidence that's been provided in response is unconvincing. That is not a reversal of the burden of proof. There is no error of law. If I am right on those 2 points, and right on the procedural fairness point, then all that is left on the challenge to the revocation under CS1Z is a rationality challenge. My lords, I'm not sure if that is a challenge which is pursued.
It is.
It is pursued.
Yeah, as I understand it, that's the thrust of Mr. Malik's complaint. In particular, he criticises what he would describe as a leap of logic at paragraph 21 on page 218. In other words, the reasoning appears to be Ms. Rima is not fulfilling the full range of duties outlined, and therefore we conclude it's been exaggerated in order to facilitate her stay in the UK. That's a pretty big leap of reasoning.
My lord, we say firstly that this is where the St Andrews principles apply again.
Right.
And that's at paragraph 16 of our skeleton argument. I won't take you back to the authority. You've been taken there several times already. Firstly, there's a need for a high degree of trust. There is an expectation that a sponsor must act with all of the rigour and vigilance of the immigration control authorities. The sponsor must maintain its own records with assiduity. The scheme emphasises certainty in place of discretion, on detail rather than broad guidance. The Secretary of State can and indeed should suspend or revoke if she has reasonable grounds for suspecting that a breach of immigration control might occur. The Secretary of State is entitled to maintain a fairly high index of suspicion, light trigger when deciding when and with what level of firmness to act. The court's role is supervisory. We've also had reference to the sponsor's licence being a fragile possession. So all of those apply when addressing the rationality challenge. We say that given where the Secretary of State found herself, it is not easy to reach dishonesty, because you have a stark contrast between what Ms. Rima said in the interview, which does not mention doing care plans, does not mention rotas, and what she said or what was said on her behalf in the submissions to which Mr. Malik took you, and in her statement of truth, so-called.
But what was the evidence before the Secretary of State that this state of affairs had been brought about in order to facilitate Ms. Reba's stay in the UK, as opposed to, for example, incompetence, mismanagement, negligence, mistake? And in particular, Mr. Malik makes the submission that there was no need for them to do this. They could have facilitated her entry to the UK anyway by simply describing the vacancy as being a care worker rather than a senior care worker.
My Lord, on that last point, I've been given instructions today about the chronology at which point it was possible to become, when care workers were added to the list to allow for sponsor duties.
Right.
Now, this is not evidence which was before the court below.
Right.
It is not evidence that has been presented to the appellant and the respondent in these appeals. I can provide that evidence now, or I can ask for it to be provided to you in due course if you were to permit it.
Well, do you want to tell us what the point is?
The
and then
point
we'll
is,
see how we proceed procedurally.
Ms. Reba's certificate of sponsorship is dated the 8th of February 2022. I am instructed that care workers were added to the list on the 15th of February 2022. Ms. Reba, of course, was a senior care worker, which was on the list before.
Right. Well, I'll hear what Mr. Malik says about that as a matter of evidence and procedure in this court, and then we'll decide what we do with it if there's any objection taken to the way in which this has been adduced. But I don't want to interrupt the flow of your submissions.
I'm grateful, my Lord. The only other point I would make in response to what you have put is that this goes back to what was said in Balajigara. There is the need for an explanation. If that explanation is not provided or is unconvincing, then it is open for the Secretary of State to infer dishonesty. And applied to the analysis are all of those points that I've just taken from London St Andrews. Light trigger, high index of suspicion, etc., etc. And the basis for that, as Mr. Magnall put to you before, is that these are, in effect, dip samples. You cannot go around and check every single individual migrant worker. That is why there is a very high index of suspicion that is maintained. One of the reasons why there is a high index of suspicion maintained. We say that when all of that is taken into account, it was a rational decision to find dishonesty. We also say that facts which have emerged since that decision was taken further the rationality of that finding. And here I take you to Ms. Reba's statement, which was provided after the decision in June 2023. It is at, July 2023. It is at page 123 to 124.
In which bundle?
The supplementary bundle. Paragraph 12 is the critical paragraph.
Did she file this in the High Court proceedings?
This accompanied the pre-action protocol that was on the High Court proceedings. This statement, unlike the statement of facts, which was provided in response to the suspension letter, this is attested by a statement of truth, which is signed by Ms. Reba. Paragraph 12 lists what Ms. Reba says as part of my job description, following are which were / are performed by me. There is a degree of repetition in here. I think there's been a slight format. But if you read those points, A to L, notably absent anything to do with shifts and rotas, anything to do with creating care plans. This is, of course, in the context of not just the suspension letter, but the revocation decision, where the Secretary of State has pointed out those two precise points are the ones that have caused her difficulty. So the position from Ms. Reamer is, at interview, there is no evidence that she is involved in shifts and rotas, no evidence that she does care plans. In the statement of facts, there is an express claim that she is undertaking work in respect of shifts and rotas and undertaking some administrative duties. And then in this statement, attested by a statement of truth, we are back to the position of the interview. There is no evidence in support of that. We stress, in relation to the point made earlier, that the finding of dishonesty is one against the sponsor, not one against us. My Lords, I have 5 minutes left. This is the final point, further point, which is the misinterpretation of the guidance point, and I think I can be brief on this. The misinterpretation of the guidance would be an error of law were it to be made out, except we say the relevant legal principles from St Andrews here are the second, third and fourth. The second is that the grant of a certificate is a privilege which carries great responsibility and requires all the rigour and vigilance of the immigration control authorities. The sponsor must maintain its own records with assiduity, and that the points-based system has created a system of immigration control in which the emphasis is on certainty in place of discretion, on detail rather than broad guidance. So we say it is not open in those circumstances to seek to get around the duties that you sign up to when you voluntarily sign up to the system. It is not open to you to seek to get around them by referring to a need to interpret everything holistically. That rigour is emphasised by the guidance. If I may briefly take you to that. Supplementary Bundle 207.
Yes.
3.5. When you assign a certificate of sponsorship, there is certain information you must include on it for it to be valid. The fifth bullet point there is details of the worker's job, including job title, job description, and occupation code. There is more information provided about the occupation code at Supplementary Bundle 210, paragraphs 3.24 onwards. I particularly highlight 3.24. When you assign a certificate of sponsorship to a worker, you must specify the 4-digit occupation code, the SOC.
I'm sorry, which paragraph were you looking at?
3.24, page 210.
Yeah, let me just read that. Yes, thank you.
And then you can see that there are hyperlinks here to the guidance, which will assist the sponsor in working out which code is needed. That's referred to in particular at 3.24 and 3.25. Then at 3.29 at the bottom of that page, you are responsible for choosing the correct occupation code. We cannot help you with this. Further guidance is flagged. S 3.30, it is essential that you select the correct occupation code, otherwise action might be taken. Finally, 3.36.
Can we just go back to 3.30 in line 4? This may be significant. If you have provided false, misleading, or otherwise incorrect information, we will take compliance action against you.
Yes.
Is that helpful?
It is, my lord. I'm sorry, I should have flagged that as well. That's carried over. I won't take you back to it, but that's carried over into Annex C1S, which you can take into. And of course, that's C1, so it is a mandatory ground for revocation. That is how seriously the Secretary of State takes this. And just to drive that point home, 3.36, significant error of a COS. You must withdraw a COS and assign a new one if you have made a significant error, such as you've entered the wrong occupation code. As Mr. Magnall has said, it is for the Secretary of State to determine those rules. If you sign up to them, then you must play by them. That is why we say that too was a mandatory breach. I won't say any more about the application to this case. It's in the skeleton argument. Say that the points that were made by Lord Justice Baker earlier are precisely the ones that we make here. This is not a minor or a trivial thing. This is the very thing that distinguishes a senior care worker from a care worker. My lords, unless I can assist further, those are my views.
Malik, you're entitled to reply on the respondent's notice points, and
Yes.
you have 15 minutes
Yes.
if you need them. I apologise for whoever's shouting outside.
Yeah. Some learned friends for the Secretary of State adopt the point that my Lord Justice Singh made on the question of fairness, namely that the policy is the starting point.
Well, I'm just thinking aloud
Yes.
what the principle is in this area.
Yes. My Lord, I would not, with respect, disagree with the proposition that in assessing whether the Secretary of State has acted in a procedurally fair manner, the starting point can be the policy. But it is ultimately a matter for the court as to whether fair procedure was followed.
Yeah.
The policy, my Lord, which you have seen, is not exhaustive. And of course, you have seen part of the policy that refers to suspension of the licensing and licenses and sending of letters. The policy, for example, does not say anything about the content of a suspension letter. I mean, if, for example, the Secretary of State suspends a license and sends a letter which simply says, I have suspended your license, and then in due course revokes the license, the court, in my respectful submission, will have a role to play. So although even in that situation, the Secretary of State would have followed the terms of the policy, but that does not render the decision-making process fair. So the common law, in my respectful submission, comes in where there is a gap, and there is a gap for the purposes of the submissions that I have made. And Balaji Gari, of course, is a classic example of where the court used common law to fill the gap. And in my respectful submission, Mr. Justice Win Williams in New London College wasn't really saying something that was materially different. His point essentially was that the policy itself cannot dictate what is or what isn't fair. My Lord, it isn't my submission that a second interview was needed. In this case, I was merely giving an example of the steps that the Secretary of State could have taken. My learned friend took my Lords to duty and asked the court to look at the 6 principles. Of course, my Lords will look at those 6 principles in conjunction with what various courts have said about them in case law that followed duty. The final authority on the subject that in my respective submission sets out the principles accurately is Balaji Gari. The test that ought to be applied is one that is set out at paragraph 55 of that judgment. The question that my Lords, in my respective submission, should ask is whether the Secretary of State clearly indicated that there was a suspicion of dishonesty before making the decision. My learned friend says that word believe means suspect. Submission is that it does not when one looks at that word as it appears in the suspension decision with paragraph 7. But even if I'm wrong about it, my Lord, I made a further submission. Lord, if you the ultimate finding against SCL is that they were dishonest. At no stage prior to the revocation decision, the Secretary of State alleged dishonesty or put or suggested that there was deliberate wrongdoing. So you have seen the suspension decision where the Secretary of State at paragraph 7 said that, well, the vacancy is not genuine, and then the relevant parts of the guidance are set out. But what the suspension letter does not say
suspension letter or decision letter?
No, the suspension letter. So my learned friend says that, well, suspension letter is effectively a minded to refuse letter.
Yes.
But even in that letter, dishonesty is not alleged. It isn't suggested in that letter that there was deliberate exaggeration on part of SCL or deliberate wrongdoing. There was certainly no, in my respective submission, clear indication in that letter that what was alleged by the Secretary of State was dishonesty. If you wish to see the suspension decision, it is in
56.
It's page 56 of the bundle.
Yeah. So the way in which the belief is described is, for example, 46, we believe the issues described above constitute failure to comply with your sponsor duty.
Yes.
And we see that similarly set out elsewhere. But your submission is that they did not clearly indicate in that letter that what was being alleged was dishonesty.
Yes. So the paragraph that appears in the revocation decision that there was exaggeration
to facilitate entry into the UK.
That does not feature in the suspension decision, of course, unless I've missed something.
That's a critical point.
Yeah. So, and that is the reason when I started my submissions, I took the court in my opening to paragraph 55 of Balaji Gari. The submission is no clear indication of wrongdoing.
Yeah, but I think that, if I may say so, in your submission, the emphasis in the proposition may subtly have shifted from suspicion to the more fundamental point.
Yes.
You never said anything about dishonesty in the suspension letter.
Yes.
Even if that is a minded to procedure.
Yes.
First time, I'm not saying you're right, but your submission is first time your clients learned that what they were being accused of was dishonesty was in the revocation decision.
Yes, but of course, subject to my other point that even in the revocation decision there isn't there isn't a clear finding of dishonesty. Yes.
I understand.
Yes. Lord, my learned friend says that my complaint really comes down to the point that word deliberate is missing from the relevant paragraph in the revocation decision, where there is a reference to exaggeration, but not sort of deliberate exaggeration. Of course, that isn't my point. My point is more fundamental, that Secretary of State hasn't really applied her mind to the actual question as to whether there was dishonesty. So from concluding that there was mismatch, there was a straight jump to the conclusion that there was exaggeration.
Now you're on the decision letter at this point.
Yes, the revocation decision, yes.
I think what Mr. Hill was saying, if you're moving away from the suspicion, from the suspense,
Yes.
suspended. I think Mr. Hill's point on the decision letter was you have to look at the whole letter in the context of the policy, which you're, of the guidance.
The suspension decision.
No, if you're not talking about the decision
Yes.
letter.
Yes.
I think his point was,
Yes. Yes.
you look at the whole of the decision letter,
Yes.
and you can see clearly from that there was a finding of dishonesty.
Yes, and my submission is that a finding of dishonesty is quite serious, and it's not a finding that one should make lightly. If the Secretary of State is alleging that a care home as significant as SCL has acted in dishonest manner, then that is a point that ought to be made clearly. It ought to be explained to them that they were dishonest and with some reasons, not simply from the conclusion that there is a mismatch to the finding that there is exaggeration. But even if one looks at the letter as a whole, I do respectfully maintain my submission that there isn't a finding of dishonesty there.
Yeah. Of course, going back to the suspension letter, if I may, at that point there were two employees about whom there were concerns.
Yes.
Has that any relevance to what was being alleged against your clients?
Yes, it is relevant to my point about
course of dealing. Is that sort of what's happening here? If there are two cases where there aren't it looks as though there aren't genuine vacancies, does that suggest a course of dealing which was indicative of dishonesty? Was that part of the case being put in the suspending letter?
No, in my respectful submission. I mean, if you look at the suspension letter, I mean, you have of course seen the paragraph that I took you to.
Paragraph 7.
Yes.
Both again.
Yes.
Both of them are employed, wrapped up together. They're not. We are not satisfied.
Yes, because but their job description did not match the description that appears at COS. But what is missing, in my respective submission, is a further reasoning that, well, for X, Y, and Z reasons, we believe that you are dishonest. You're doing it deliberately because you have an incentive to do so. So my learned friend says that, in answer to that point, my learned friend says that, well, St. Andrews assists, and there's a high degree of trust between the Secretary of State and the license holders. It's a light trigger, a high index. But those points, in my respective submission, do not assist when it comes to the finding of dishonesty. This isn't a case where the Secretary of State is saying that I'm revoking your license because I don't trust you anymore, or because I suspect some wrongdoing. She's making a positive, conclusive finding, as she says, that there is sort of deliberate wrongdoing on your part. So St. Andrews, in my respective submission does not assist. Of course, the court will apply the due deference principle, but the Secretary of State, of course, is the expert. Her view carries weight, but it is ultimately for the court to decide whether the finding that is made was open to the Secretary of State on the evidence. My learned friend took you, my lords, to the witness statement evidence that you have in the bundle. And unless I've got the reference wrong, I think my learned friend took you to page 122 of the bundle. This is Miss Reamer's witness statement. Sorry? 123, yes. Yes, so and my learned friend highlighted paragraph 12 at page 123 and said that, well, Ms. Reamer said in the witness statement that, well, these are my, I'm performing these duties. May I take you to that document? This is, this fact, an important point that I need to deal with.
Supplementary bundle, isn't it?
Sorry?
Supplementary bundle.
Supplementary bundle, yes. So supplementary bundle, page 122.
Paragraph 12.
Paragraph 12, yes. And learned friend says that, well, look at this list and then look at the job description. And there isn't anything about leadership roles or administrative duties. But what my learned friend inadvertently omits is to highlight what follows. So paragraph 14 says that in addition to the duties mentioned above, in addition, she then provides a detailed narrative of the leadership duties that she's performing.
I think the point he was making was that in the original interview, she didn't say that she actually did shifts and rotas and created care plans. And then there was a statement after that, which was provided to the Secretary of State, in which it was asserted that she did. And when one comes back to the list here, it's absence again. I think
Yes,
that was the point that was being made.
yes,
But
but
those particular points, wasn't it?
of course, but if you look at the list in isolation, that would be the case. But see paragraphs 14 to 20. She refers to the interview. I mean, for example, see paragraph 19. I mean, this is the leadership role that she. I mean, there's absolutely no doubt that that she is performing on this evidence the duties of a senior care worker. But can I, just for completeness, take you to the next page, page 126. So not only that, evidence was adduced below from the care manager. And see what the manager says. Paragraph 8, that she is involved in care planning, liaises closely with care coordinators. This is paragraph 8 of the witness statement. There is more, page 129, 131. There are statements from senior care coordinators, certain workers, all attesting to what she was doing.
Shifts and rotas, are they mentioned in these statements?
Lord, I'm afraid I do not know the answer immediately. I'll just double check. Yes, page 109. You've looked at this. This was actually before the Secretary of State when the revocation decision was taken. So this is the statement of fact, paragraph 7, allocate shifts and rotas. Yeah.
This is the earliest
I
statement.
think that was the point that was being made, yeah.
Yes, paragraph 7.
That's very helpful.
So you don't in my submission simply look at that list in isolation. I mean, this evidence, and that is essentially the reason why I'm inviting the court to uphold the order. If the Secretary of State looks at all this evidence now and retakes the decision in my submission, the reasonable likelihood is that she would see that there is a genuine vacancy. Just one final point, which concerns the new
Yes.
information that is provided. In my submission, it's too late for the Secretary of State to provide any evidence now. The Secretary of State had every opportunity to put in a defense, to put in evidence during the judicial review proceedings. It's just too late. I mean, the Secretary of State has to meet the Lad and Marshall test, and this isn't in my respectful submission appropriate, where an appropriate case where the Secretary of State should be allowed to put in further evidence. Now, this is the point that SCL made very clearly in representations that followed the suspension decision.
Can you just show us that passage? Is it the letter page 66?
Yes.
Right. And where did they make?
Sorry, page. Page 69 of the bundle.
Yeah.
Can I just give another reference?
Yes, of course.
Yes, so that is that. And can I just also ask, my lords?
Just before we leave it, can you just show me the specific passage where they made that point?
Yeah. So this is.
I'm not saying they didn't. I just want to see it. That's all.
Yes. No. This is. You'll see. This is the second paragraph where they said that both care workers and senior care worker positions were placed on the shortage occupation list. So that's that. And this is the point, my lord, that I pleaded in my grounds of judicial review. I picked that point.
Are you able to give us a reference?
Yes, it's page 160 of the core bundle. Paragraph 21 of my statement of facts and grounds of judicial review.
Core bundle, page 106.
160, my lord.
Sorry, 160. Paragraph.
The first paragraph. This is paragraph 21. The paragraph starts at page 159.
Right. And what's the paragraph number?
So paragraph 21.
Thank you very much. And what's the point you were pleading?
Well, precisely this point, that the claimant had no incentive to deliberately mislead the Secretary of State. Both the role of care worker and senior care worker remained on the shortage occupation list, and so on.
Right. Is there any other reference? I think you were about to take us to another reference.
Thank you.
Was there,
I'm good. It's just that my learned friend, of course, highlights that this is the point that I made in my skeleton argument as well.
Which skeleton argument? Here or below?
Well, both, in both skeleton arguments.
Right, okay, let me just note that. So the point was made in the skeletons here and below. Are there any other references you want?
Yes, it's paragraph 39 of my skeleton argument.
In this court?
In this court, yes.
Let's just have a look at that. Yes. Yes, it was something that I had highlighted earlier this week when I read this.
Yes. So, unless I can insist, Lords, any further, these are my submissions.
May I check if there are any questions?
Thank you.
Thank you all very much. Sully.
My Lord, can I just raise one matter? In my reply, I made the point about the statistics that had been provided in response to a question from my Lord Justice Baker. Mm-hmm. I mentioned that we'd requested more specific statistics overnight. I am informed that they are with Secretary of State's junior counsel at the moment. Obviously, we would then they haven't been disclosed for whatever reason. I'm not critical of that, but we would ask firstly that they are disclosed because, in one sense, they give a more relevant picture. And I very much doubt we need to say anything more because obviously we've referred to the relevant evidence about the impact on employees, which I don't think is inconsistent necessarily with statistics. But when I don't know what is going to be shown, I just reserve the opportunity to say something if necessary. I highly doubt that that will be necessary.
In writing?
In writing, of course, yes.
Right. Can I ask Mr. Bankton, what is the position? How quickly will you be able to get us this if we are going to get something?
Well, Lord, I have an email in front of me. So the request was made yesterday. The statistics have been collected. So there's effectively a draft email which provides the statistics requested. It has a spreadsheet attached. And my client also considered it's necessary. There's a paragraph that explains the process that's currently being adopted to match people who have lost their place of work due to licences being revoked. So it sets out where the sponsors are and which ones have been revoked. We're in your hands. At this stage of proceedings, there's perhaps little point in providing it to the appellant without providing it to the court, but I don't want to provide anything unsolicited if the court doesn't consider it appropriate. So our suggestion is simply to provide it to the appellant and to send it to your clerks at the same time.
And how quickly could you do that?
I do want to just check one or two features of this to make sure there's nothing in there that shouldn't be there for any reason, but certainly by tomorrow morning.
All right.
My Lord, no issues in relation to that, save for one thing, because we weren't aware that this material potentially included a statement about the process for matching workers with new sponsors. Can I ask that it's confirmed that that was the process at the material date, because that's obviously relevant, not a current process, and because obviously telling you what the process is now doesn't really help in terms of the impact of material time.
That's a fair point. I'll make sure that's checked.
Yes.
It also occurs to me, my lords, that if we are providing this to you, whether you want the figures that I provided on instructions put into that
Yes, I think we
15,000
should.
to the precise figure.
I think we should. Yeah, and what I'll say is, well, this needs to be filed and served by 12 noon tomorrow. I'm not necessarily saying that we will give permission to adduce any of it, because we will consider its contents, and if we consider that any of it is not admissible at this level and at this stage, then we will deal with that in any judgment of the court. And I will give Mr. Southey an adequate opportunity, if so advised, to respond in writing. If we said 4 p.m. on Tuesday, would that give you enough time if you do need to respond to something?
I'm sure we can work with that. I'm in court Monday and Tuesday, but I'm sure it's something my junior can deal with.
Well, you can always ask for an extension if it's not realistic, all right? But at the moment, we will direct 4 p.m. on Tuesday of next week for any. And I'm not encouraging you to file a response, but if you need to, then you can.
And I think I've indicated I'm not anticipating I need to, but obviously.
Can I just check? Thank you. Can I just check with counsel if there's anything else before we finish? Can I check with my lords if there's anything else? Then all that remains, but importantly for me to say, is that we're very grateful to everyone, not only those who have made submissions, because we're well aware of how much work goes into the preparation of a hearing like this. And we will, of course, reserve our judgments. They will be circulated in due course on the usual confidential terms. And I must stress, as this court has frequently stressed in recent years, how important it is that the embargo should be respected. At that point, this court takes very seriously any breach of the embargo. The reason why the judgments are circulated in draft in advance is not so that there can be another round of submissions, or for any other purpose, save the limited ones of correcting typos and any obvious factual errors. Thank you all very much.